Hello and welcome to the third video in our redundancy focus mini-series. I'm Charlotte Geesin, and during the course of this video I'm going to talk to you about redundancy selection criteria. Once an employer has identified a genuine need to make redundancies and worked out which employees should be pooled for selection on the basis of the work of a particular kind which they undertake and how this compares with the work which is ceasing or diminishing overall, an employer needs then to look at the selection criteria which it will use to select from those employees who are at risk of redundancy, those who will actually go on to be made redundant. In the event of a dispute, a tribunal will consider the reasonableness of any selection criteria applied. And whilst there's no definition of what this actually means, it is generally accepted that in order to be reasonable, redundancy selection criteria should, as far as possible, be both objective and capable of independent verification. This means that criteria should be measurable rather than just being based on effectively a personal opinion. An employer does have control over what criteria it implements. There are no hard and fast rules about what employers should or shouldn't rely on when carrying out a selection exercise with its own employees. But generally speaking, potentially fair selection criteria will include criteria relating to performance and ability, length of service, attendance records and or sickness records, and also disciplinary records. Whatever criteria is used, however, it is legitimate for an employer to attach weightings to those criteria, reflecting their relevant importance. Employers who do this, however, must ensure that they are able to justify any such weightings, so as to ensure that a tribunal or an employee is unable to allege that the criteria were unfairly stacked in a particular individual's favour or detriment. Where possible, any selection criteria should be measured by reference to HR records, covering things such as performance and attendance. Where such records are patchy or don't exist at all, then the employer will have to do its best to measure employees. But this will make it all the more important for there to be more than one manager involved in the process, and for there to be evidence of the reasoning applied behind the scores awarded to the employees in respect of each of the selection criteria. Selection on purely subjective grounds isn't great. There's nothing wrong with it per se. It can be utilised, but it stands a greater risk of being adjudged to be unfair. Ultimately, subjective selection criteria can far more readily give rise to claims for bias or for employees only having been selected for redundancy because of a manager's personal animosity, or more worryingly, the employee has perhaps been selected for an automatically unfair or a discriminatory reason. Examples of subjective criteria that have been rejected by tribunals as being too vague, imprecise, or just too subjective include as follows. Employees who, in the opinion of the manager concerned, would keep the company viable. Employees who were best suited for the needs of the business under the new operating conditions. And attitude. In the particular case in question, the employer didn't expand on the criterion of attitude, and the tribunal described that particular criterion as dangerously ambiguous and vague. That all said about subjective criteria, like I said, sub-criteria may be acceptable if it is the subject of objective application. And there have been a few cases in the past in which subjective selection criteria have indeed been held to be acceptable. In a case of Howard's and Siemens Energy Services, criteria relating to company values were considered to be acceptable acceptable, and whilst arguably subjective, the tribunal said that criteria could indeed be valid. Future potential was found to be an acceptable selection criteria by an employment tribunal in Ganasan and Opera Solutions Limited. I think if you are looking at basing a selection exercise on subjective criteria or building subjective criteria into your wider scoring detail, then you should always consider taking advice on the content to ensure that it will not subject your process to any unnecessary detriment, and ultimately to ensure that it won't expose you to any unnecessarily legal risk. I think in my experience, employers tend to stick with sort of tried and trusted criteria, and commonly used criteria include things like last in, first out, the aforementioned performance and ability, and attendance records. These stalwarts of redundancy selection criteria crop up time and time again, and on that basis, I thought it was worth just giving a little bit of specific attention to each of these particular criteria. When it comes to last in, first out, or for those in the know, LIFO, this selection criteria used to be a common and popular method of redundancy selection. However, in recent decades, length of service as a selection criteria has fallen from favour as a dominant criterion. It's more likely now to be viewed as acceptable if it's used as part of a balanced set of criteria, or as a tie break when all other factors are equal. The biggest problem with last in, first out type selection criteria is that it is likely to result in claims for unfair dismissal and indirect discrimination on grounds of age and sex, even potentially where the employer is able to justify the decision-making process. It's an easy criterion for an employee to challenge, but like I say, that said, the proper handling of last in, first out criteria, which is challenging this way, won't always give rise to a successful claim. In the case of Rolls-Royce PLC and Unite the Union, which was a 2009 case, the majority of the Court of Appeal held that using length of service in a redundancy selection matrix was lawful, whilst it did constitute indirect age discrimination in that particular case. The selection criteria was nevertheless objectively justified. In that case, the court held that the employer had two legitimate aims in using that criterion. Firstly, the maintenance of a stable workforce during a redundancy exercise, and secondly, the rewarding of loyalty. The means of achieving the legitimate aim were proportionate in that length of service was one of many criteria used. It was consistent with the overarching concept of fairness, and ultimately the younger employees who raised the issue in the first place, for the most part, accepted that rationale. I think when it comes to last in, first out, then it isn't a criteria to necessarily shy away from using, but it is one that will require some careful thought and planning prior to its implementation. And I would suggest that if you are looking at crafting some selection criteria, then you do take some legal advice in terms of the content of those criteria, particularly if you are looking at differentiating employees on the basis of how long they've been with you. In terms of criterion relating to performance and ability, if an employer wants to use criteria in this regard, it's really important that that employer chooses clearly defined criteria and applies a system of weighting that relates to skill and knowledge required for both its current and its future business needs. In assessing the performance of each employee, the employer should refer to written records, such as performance appraisals, rather than simply relying on a manager's at the time of the redundancy selection exercise. It will be very difficult for the employee to challenge the employer's reliance on appraisals, particularly where the appraisals have been agreed with the employee's comments. Common problems, however, that arise in relation to the assessment of performance based on appraisals are that the appraisal may not have been carried out regularly enough, or indeed at all, for some or all of the staff in the pool. If you are going to seek, obviously, to apply criteria that need rationalising with reference to appraisal documentation, you need to make sure that, at the outset, the appraisal documentation allows you to do that. Secondly, appraisals might not always have been carried out by the same manager, or applied in the same way with a different approach perhaps being taken. That in itself can create an uneven playing field. So again, at the outset of your preparation, when you're looking at the criterion that you're putting in place, have a look to make sure that if you are relying on appraisal documentation, that overall the approach which has been taken by the company in relation to that appraisal process is broadly consistent, and there aren't any massive sort of variations in the outcomes delivered through the appraisal process. In the event that your appraisal documentation potentially causes you a problem in that respect, I think it's still fine to sort of utilise criteria based on performance and ability, but consideration to some form of independent assessment of the appraisals perhaps needs taking place, and also the overall scoring exercise definitely should be undertaken by more than one individual in order to minimise the risk of bias or subjectivity. How easy it is in practice to actually measure performance will ultimately depend on the role in question. In sub-jobs, such as those involving sales or productivity targets, performance is inherently easy to measure. Did people sell enough? Have people produced enough? Yes or no? In other jobs, however, assessment of performance will require a subjective analysis of the qualities and the skills of the actual person. And in some cases, it may even be preferable to break performance down into subcategories, each of which can then be obviously assessed separately. Provided the manager or managers in question can justify their subjective assessments, then they will carry weight. The employer shouldn't, however, make the mistake of shying away from making subjective assessments altogether if the role in question calls for a subjective assessment to be made. When it comes to the use of attendance records in redundancy selection criteria exercises, where an employer wishes to refer to attendance records, it should obviously check the accuracy of the information that's contained within those records, and also consider the reasons behind the absence before it utilises those records as a selection criteria. Consideration should be given to whether any particular periods of absence should be discounted, such as absence or pregnancy-related illness, maternity or other family leave, where an employee's absence is connected with a disability. Selection for redundancy on grounds of attendance record may amount to disability discrimination on the basis that the employer should have made a reasonable adjustment in relation to the attendance part of the redundancy selection. And in these cases, employers should always consider taking legal advice in order to ensure a successful navigation of the Equality Act, which obviously is the legislation in the UK which governs all things discrimination. Whilst any selection criteria ultimately has the potential to be being argued as discriminatory in nature, it is perhaps that which is related to absence and attendance which stands the greatest chance of being argued as such, and therefore having an awareness of the principles of discrimination at the outset of a redundancy exercise can be useful. When it comes to discrimination in the selection stage, selection criteria may discriminate against employees either directly or indirectly. Any redundancy selection criteria that discriminates directly on any of the protected characteristics, so sex, maternity and pregnancy, marital status or civil partnership, age, race, disability, sexual orientation, gender reassignment, or religion and belief, or on grounds of a fixed term or part-time status, very important to remember in a redundancy selection context, will generally result in a finding that a dismissal is unfair, in addition to a finding of unlawful discrimination. Criteria that have an indirectly discriminatory effect are also likely to render dismissals unfair if the employer is unable to demonstrate an objective justification for the adoption of such criteria. Like I say, very, very sort of clear, focused, detailed thought to selection criteria is genuinely necessary in order to ensure that you don't fall on the wrong side of the law when it comes to discrimination. And as aforementioned, used as a sole criteria, the last in, first out criteria is highly likely to be indirectly discriminatory on the grounds of both age and sex, and the use also of attendance records can raise issue of sex and or disability discrimination. In the absence of any justification, a dismissal may be both unfair and discriminatory, and it's therefore unwise to rely solely on criteria like this, and it's important to ensure that legal advice is taken so that other objective factors can be built in and used as part of the overall selection process. Moving away from the criteria itself then and on to the selection process, employers should be aware that before choosing employees from the pool to be made redundant, they must consult with the employees about the scores which they have been awarded. This consultation meeting should take place after the at-risk meeting, so the meeting that you've had with the individuals to tell them that ultimately, due to business reasons, their role is at risk of redundancy, but before the onset of formal individual consultation. So the meetings that you will have with the lowest scoring employees to discuss ways, potentially, hopefully, of avoiding redundancies. In the meeting to discuss the outcome of the scoring exercise, the employer should disclose individual scores to the employee, explain how they were arrived at, and give the employee a chance to challenge his individual markings as part of the wider selection exercise. Where the employer is considering sharing the scores of other employees, it will be necessary to consider any data protection implications of doing so. We all love GDPR. If the other employees can be identified from the scores or breakpoint, whether or not they are named, then the employer does need to consider whether the scores contain personal data or special category personal data, previously sensitive personal data, and if so, obligations under the relevant data protection legislation, and that includes GDPR, will need to be considered. Usually in practice, where the pool is sufficiently wide enough for employees not to be able to work out who's being scored what, when everything is kept anonymous, then the sort of perhaps the easiest way of sort of presenting the employee with the scores is making anonymous the overall scores, but allowing the employee to see how their scores for each criterion compare with the others in the pool, and also how they rated overall. Once the selection process has been completed, and what I mean by that is once you have completed the discussions with the employee about their scores and made any necessary adjustments to the scoring process, which may be necessary following discussion with the employee, then the employer will be in a position to be able to begin consulting with the lowest scoring employees. The sort of thrust, if you like, of this part of the consultation is ultimately to trying to find an alternative to redundancy, and that includes undertaking a search for any suitable alternative positions of employment within the organisation. The duty to search for suitable alternative employment is a well-established duty. An employer must look to see what alternatives exist. And in discharging this duty, an employer must consider vacancies which may exist within its own organisation, but also within any wider group of companies and sister companies. So don't forget that your search needs to be, far-reaching, sufficiently far-reaching in that respect. Although an employer has to look across all companies, organisations within the group to see if there is any suitable alternative employment available, an employer is not obliged to create alternative employment for redundant employees where none actually exist. The law doesn't require employers to go that far. Employers should make sure that they undertake a sufficiently thorough search for alternative employment and that they document their search, ultimately to show the steps that they have taken should it become necessary to produce evidence in defence of an unfair dismissal claim. Since the fairness of a redundancy dismissal is judged not only at the date on which notice of termination is given to an employee, but also when an employee's employment actually terminates, an employer should ensure that it continues to search for possible alternative employment until the date on which an employee's dismissal takes effect. So basically, what that means is you are under an obligation to continue your search for alternative employment for an employee who is dismissed as redundant through their notice period. In the event that you terminate your employee with a pylon, then the situation can be different. But any employee who works their notice or is placed on garden leave or is on furlough leave, then that obligation to continue the search for alternatives will continue to apply, and it's important to remember that. An employer is not normally obliged to delay termination of employment once notice has been served in order to determine an employee's application for alternative employment. Where an employee makes an application for alternative employment so close to the termination date that the full recruitment process cannot reasonably be completed prior to that employee's employment ending, the dismissal will normally take full effect, but the employer should nevertheless continue to process the redundant employee's application for alternative employment. Without overcomplicating things, in these circumstances, the statutory scheme under Section 138 of the Employment Rights Act 1996 will not apply because no offer of suitable alternative employment has been made before the original contract terminated. This basically means that the employee will remain entitled to a statutory redundancy payment in the normal way. However, if they are subsequently re-employed, then receipt of the statutory redundancy payment will sever continuity of employment in relation to future statutory redundancy pay claims. So in light of this, an employer in these circumstances may actually wish to agree an extension to the notice period with the employee during which their application is processed in order to ensure that any offer of suitable alternative employment is actually made prior to employment terminating and therefore falls under the statutory scheme with regards to the redundancy payment itself. In discharging the primary duty to look for alternatives to redundancy, employers should also provide employees with sufficient information about any vacancies so that they are able to take an informed view themselves as to whether the position is suitable for them. An employer should never assume that a vacant role is not suitable for a particular individual because perhaps it would involve a reduced status or reduced salary. All potential alternatives should be brought to the employee's attention for their consideration. If an employee accepts an offer of alternative employment, then it may be subject to a statutory trial period of 4 weeks. So do remember this. The 4-week trial period, which can be extended in some circumstances, is essentially there for parties to assess whether the role is actually suitable. If the employer refuses to allow the trial period, then any subsequent redundancy dismissal could be unfair. So it's really important that if it applies, the trial period is something that is offered to the employee. And the same could be true in the sense of the redundancy dismissal being fair if the employee in breach of contract refuses a contractual trial period entitlement. So have a look at the employee's contract of employment to see what it says about redundancies and trial periods, if anything, because it may be something that becomes relevant on the offering of suitable alternative employment. Before I bring this video about redundancy selection to an end, I just wanted to mention the concept of voluntary redundancy, because this is something that many employees ask about, and something which actually can be to an employer's overall benefit. I'm a big advocate of giving the employees chance to apply for voluntary redundancy. And prior to commencing a selection process and or redundancy consultation process, I generally recommend employer seeking volunteers for redundancy. The main reason that I tend to take this approach is that it can ultimately make your life easier. Because if you get people volunteering for redundancy, it may potentially completely remove the need for you to actually subject anyone to compulsory redundancy proceedings. If you get sufficient numbers of employees applying for voluntary redundancy at the outset, then like I say, it can completely remove the need for you to then move forward with the somewhat difficult conversations with other employees. Similarly, with voluntary redundancy, you don't have a huge amount to lose, because voluntary redundancy is actually an application process. An employee doesn't have a right to be made redundant, subject to any voluntary redundancy request. And although it seems to fly in the face of all established employment law principles, employers can reject voluntary redundancy applications if the wrong person applies, and to accept any such application would potentially upset business operations, or prevent an employer from retaining the best of its talent, skill and experience. Employers who choose to offer voluntary redundancies should obviously try and keep a degree of control. Ultimately, you don't want to be losing any of your key staff. And if you do decide to go down this route with any redundancy processes that you may follow, I would recommend that you make it clear to the employees in question that you will consider all requests for voluntary redundancy, but that you actually reserve the right not to accept all or any such applications, particularly if there are more applications than the proposed number of redundancies, or if you consider that in the long-term interest of the business, it's important to retain certain employees. You should also consider stating that you may have to still make compulsory redundancies if you don't receive a sufficient number of appropriate volunteers. And also, you may want to sort of seek to reassure employees who are interested in applying for voluntary redundancy that if they do volunteer but are then not selected, the fact that they volunteered will not be taken into account when any compulsory redundancy decisions are made, or in relation to their future employment, because the law prevents you from doing that, and also that they can change their mind and withdraw their application for voluntary redundancy at any time before a specified date. Obviously, you don't want employees withdrawing voluntary redundancy applications left, right and centre, particularly following a point where you have made a decision about who is staying and who is going and what any future consultation process is going to look like. But if you sort of attach a deadline date for withdrawals, then that's absolutely fine. If an employee volunteers for redundancy in response to an employer's invitation, this will still count as a dismissal by reason of redundancy. An employee can still claim unfair dismissal, even though effectively they've chosen to go. This is why an employer can only invite applications for voluntary redundancy from those employees whose roles are actually at risk of redundancy, and not from a wider employee body. It's not appropriate for an employer who needs, for example, to make cost savings, to say to every single one of its employees, right, we need to make cost savings, does anybody want to apply for voluntary redundancy? That won't work. You still have had to have satisfied the basic principles of the Employment Rights Act for when it comes to there being a need for a genuine redundancy situation. Obviously, the reduction or cessation of work of a particular kind point being relevant there. So do just bear that in mind. On a final point, in respect to voluntary redundancy, a voluntary redundancy termination does not lawfully attract any additional severance pay. An employee is still entitled to notice pay and redundancy pay, and then any sort of final salary payments, accrued holiday pay, etc. But there is no automatic obligation on an employer to enhance the the termination payment, either in terms of notice pay, redundancy pay, or otherwise, for an employee who volunteers to leave. Many employees will ask for a deal to be done should they choose to make themselves voluntarily redundant, and it's something that you are entitled to explore, depending on the employee in question, the facts of the particular case. You may or may not decide to offer a particular enhancement. I think if you are looking at doing this, particularly if you're not looking at offering enhancement across the board and you're seeking to only offer enhancements to certain individuals, that it's going to be important to take legal advice to ensure that any approach doesn't sort of leave you in a sticky spot when it comes to any of the applicable legislation, including the Equality Act. Well, I hope that you found this video useful. Join me for part 4 soon, during which we will look at redundancy termination arrangements, redundancy termination payments, appeals, and unfair dismissal claims.